Good afternoon. Before we begin today, I would like to start by acknowledging the Wurundjeri Woi-wurrung people of the Kulin Nation, traditional custodians of the land on which I am presenting today, and pay my respect to elders past and present. I extend that respect to Aboriginal and Torres Strait Islander people who are listening to this webinar today. My name is Patrice Fitzgerald, and I am the Principal Lawyer and Director at Safe Space Legal. Safe Space Legal is the first law firm in Australia to practice exclusively in safeguarding. Our team of lawyers and legal support have extensive knowledge in safeguarding and bring a holistic approach to our work, having significant expertise in law, child protection, institutional abuse, social work and disability. It is our great pleasure to present to you today a webinar on the new Child Safe Organisation system in Queensland. Before we start, I just wanted to say that some of the content I will be discussing today can be quite confronting and distressing, as we will be talking about child abuse and harm. This content may be especially triggering for those who have experienced abuse or know someone who has. Should you at any time feel that the content is distressing or triggering, please feel free to take a break. I also encourage you to seek support either within the organisation you're working or externally. There is some numbers listed on the screen for some external supports if needed. What's on the agenda today? I'm going to give a little bit of a background to the legal framework in Queensland. I'm going to talk about what is the Queensland Child Safe Organisation system. I'm going to take a bit of a deeper dive into the child safe standards and the reportable conduct scheme in Queensland. And most importantly, what organisations should be doing now. So some considerations for you now if you're working within an organisation that works with children and young people, what you should be doing now to prepare for the new framework. On the 12th of November 2012, the Australian Government announced that there would be a Royal Commission into the institutional responses to child sexual abuse. Throughout the 5-year Royal Commission, 42,041 phone calls were received, 25,964 letters and emails were received, 8,013 private sessions were held and 57 public hearings occurred. From this, 2,575 referrals were made to authorities in relation to concerns of children being abused and harmed within institutional settings. The final report was released on the 15th of December 2017. The Royal Commission made 189 recommendations aimed at ensuring children and young people in the care, supervision and authority of organisations would be protected from harm. We do not have time to talk about each of the recommendations made by the Royal Commission, but I do want to focus on 2 recommendations that came out of the Royal Commission that has essentially changed the legislative landscape within most states and territories in Australia. And that is the Child Safe Standards and the Reportable Conduct Scheme. And this really is the background that has led to the new Child Safe Organisation framework in Queensland. Firstly, I'm going to briefly talk about the background to the Child Safe Standards here in Queensland. Specifically, recommendation 6.4 stated that institutions should be upholding the rights of a child, consistent with the United Nations Convention on the Rights of the Child, by implementing 10 Child Safe Standards. The Royal Commission recommended that the 10 Child Safe Standards be implemented by organisations nationally. And in February 2019, the Child Safe Standards recommended by the Royal Commission were essentially endorsed by all states and territories across Australia and became known as the National Principles for Child Safe Organisations. The National Principles are aimed to provide a nationally consistent approach to creating child safe organisations in Australia. Some states and territories across Australia have legislated the National Principles, and organisations in those states and territories are legally required to comply with the national principles. And they may be known as different names across other states. So, for example, in Victoria, they are known as the Child Safe Standards. In Tasmania, they're known as the Child and Youth Safe Standards. Legislation across the states that have implemented the national principles is similar, but also there are some variations. So to give you an example, in Victoria, there are 11 Child Safe Standards. And now in Queensland, the Child Safe Standards have been legislated, and we're going to dive deeper into the Queensland system in a minute. The other recommendation I wanted to focus on is the Reportable Conduct Scheme. All states and territories that implement a Reportable Conduct Scheme are overseen by a state-based regulator. And So each state has a different regulator that oversees the system. So there's no one Australian system in regards to a reportable conduct scheme. And as we know, Queensland are bringing in a reportable conduct scheme shortly, which I'll go into in a moment. But what is a reportable conduct scheme? A reportable conduct scheme is a scheme that oversees the conduct of employees and volunteers within institutions who work with children and young people. Reportable conduct schemes are designed to ensure that allegations of child abuse and misconduct within institutions are properly reported and investigated, and that a government regulator is responsible for oversight of the institution and institutions' compliance with the scheme. The purpose of the reportable conduct scheme is it's really twofold. Number one, it is to ensure that people who work with children and young people are suitable. So the central regulator, the state-based regulator in the state that you're living or you're working, has a bit of a central record base about any allegations made against employees within organisations. But it's also to ensure that the institution itself is taking complaints, disclosures, reports and critical incidents seriously and responding appropriately. Organisations who are required to comply with the scheme must ensure that any reportable allegation that is made must be reported to the regulator. They must be investigated and findings made, which are also then reported back to the regulator for oversight. I have personally spoken with many clients who have found the child safe standards and reportable conduct schemes to be quite onerous, but it is essential that all organisations recognise that there's a good reason why these frameworks and systems are onerous. All you need to do is look back on the abhorrent history of child abuse within institutions in Australia, read some of the stories and case studies that came out of the Royal Commission, and you will understand why a child-safe organisation system is needed within all states and territories, and now within Queensland. I'm now going to turn to the child safe standards and the child safe organisation system in Queensland. So in 2024, the Queensland Government passed new legislation, the Child Safe Organisations Act, which is designed to promote the safety and wellbeing of children in Queensland within institutions. The legislation has two key parts which will bring into effect the child safe standards and the reportable conduct scheme in 2025 and 2026 respectively. And I'm going to talk about that a bit in a moment. The child safe organisations and the reportable conduct scheme frameworks will both be introduced in a phased approach, which means that different sectors will have to make their legal responsibilities at different times. As every organisation in Queensland will be at a different stage of compliance, there will be sector leads who will mostly be Queensland government agencies who will implement the legislation in a way that best suits the organisations within that sector. In Queensland, the Queensland Family and Child Commission will be the regulator that will oversee the implementation of the child safe standards and the reportable conduct scheme. The regulator will provide information and assist organisations to comply with the new scheme, and it will also provide oversight and eventually will have powers to ensure organisations are complying with the child safe organisation system and will have powers to enforce compliance with the system. It's very important that organisations are aware of the QFCC's role and ensure that any information that is released by the Queensland Family and Child Commission to assist organisations to comply is properly read and understood. The new Queensland Child Safe Standards are based on the national principles, which, as I said, was endorsed by all Australian states and territories back in 2019. This means that the framework in Queensland will be consistent with schemes operating in other states, but there are also some variations in the legislation. So organisations that work nationally or may work in different states across Australia need to be aware of what the differences are and the variations in the legislation, because there are some variances. Any organisation which is based and operating in Queensland, which is deemed to be a child safe organisation by the Act, will be required to uphold the 10 child safe standards. So Chapter 2 of the Child Safe Organisations Act sets out the obligations to comply with the child safe standards. Section 9 of the Act sets out the meaning of the child safe standards, and Section 10 sets out what organisations are deemed to be child safe entities and are therefore required to comply with the child safe standards. The 10 child safe standards in Queensland are underpinned by the Universal Principle. The Universal Principle requires that organisations ensure that it provides a culturally safe environment for Aboriginal and Torres Strait Islander children. The universal principle is embedded in each of the child safe standards, and organisations must ensure that it tailors the universal principle and the child safe standards holistically to the whole organisation. It requires that institutions ensure that Aboriginal and Torres Strait Islander children can express their culture and enjoy their cultural rights, with staff and volunteers being required to understand the importance of culture for the wellbeing and safety of First Nations children, including by addressing issues of racism and discrimination. Institutions should also promote and support participation and inclusion and ensure all policies, procedures and processes are culturally safe and inclusive, and that cultural safety is implemented across the organisation. I'm now going to go through each of the 10 child safe standards briefly. Please remember that when implementing these standards, you must also ensure that you're embedding the universal principle into the implementation as well. So Child Safe Standard 1 is that child safety is embedded in institutional leadership, governance and culture. This requires institutions to publicly commit to creating a child-safe culture, to ensure that child safety is a shared responsibility, have risk mitigation strategies in place which prevent, identify and mitigate risk, to ensure staff and volunteers comply with the organisation's code of conduct and understand their information sharing and record-keeping obligations. Child Safe Standard 2 is that children participate in decisions affecting them and are taken seriously. Children should be able to express their views and participate in decisions which involve them. They should feel safe and be connected to their peers so they do not feel isolated, and should be able to access prevention information and programs. Staff and volunteers should also have an understanding of indicators of harm and how to speak to children who want to raise concerns. We know that when children are empowered about their own safety and well-being, the organisation is a safer place for children. Child Safe Standard 3 is that families and communities are informed and involved. Families are responsible for raising their child and should be involved in decision-making that affects their children. Institutions need to ensure that they have open communication with families and support families to have a say about policies and procedures, as well as understanding about operations and governance. Child Safe Standard 4 requires that equity is upheld and that diverse needs are taken into account. This requires institutions to respond effectively to a child's diverse needs and vulnerabilities, particularly those from Aboriginal and Torres Strait Islander cultures or culturally and linguistically diverse backgrounds, as well as children with disabilities, and ensure children who have access to information and complaints processes. Child Safe Standard 5 is that people working with children are suitable and supported. This requires child safety focused recruitment processes. Staff and volunteers must have working with children checks or appropriate clearances, ensuring proper induction occurs so that they are aware of their legal and moral obligations, and there must be supervision of staff and volunteers with a child safety focus. Child Safe Standard 6 is that processes to respond to complaints of child sexual abuse and harm are child focused. So complaints handling should be child focused, clear and accessible, and all complaints should be taken seriously and responded to appropriately in line with an institutional's legal and moral obligations. Child Safe Standard 6 is also crosses over with the reportable conduct scheme obligations, which I will talk about in a moment. Child Safe Standard 7 is that staff are equipped with the knowledge, skills and awareness to keep children safe through continual education and training. So training should be provided to ensure that staff and volunteers understand and can respond to indicators of harm, to abuse and harm within the organisation, and to ensure that they understand and comply with the child safe practices and procedures which promote child safety and proactive responses to allegations of abuse within the institution. Child Safe Standard 8 is that physical and online environments minimise the opportunity for abuse to occur. Risks are identified and mitigated without compromising a child's right to privacy, and use of online environment occurs in line with relevant codes of conduct, policies and procedures. Child Safe Standard 9 is that the implementation of the child safe standards must be continuously reviewed and improved. We recommend that at least annually child safe policies and procedures are reviewed, but also after any concerns are raised or any complaints or investigations. Any time that risk is identified, the policies and procedures should be reviewed and amended. And finally, that Child Safe Standard 10 is that policies and procedures document how the institution is child safe. So this requires institutions to implement policies and procedures which align with the child safe standards, They're easy to read and access and promote best practice models. Institutional leaders should model compliance with the policies and procedures, and staff and volunteers should understand and implement the policies and procedures in their day-to-day practice. Now, what the child safe standards look like in your organisation may differ to what it looks like in other organisations. You will need to make sure that you're properly adapting your policies and processes to ensure that those children and young people are safe. The implementation of the child safe standards in Queensland will commence in a staged approach from the 1st of October 2025. There are 3 phases which outline which organisations are required to implement the standards and when. The phases are summarised on the screen above. So from phase 1, which commences on the 1st of October 2025, is child protection services, services for children with disability, justice and detention services, and government entities will come under this particular framework. From the 1st of January 2026, phase 2 will commence. That's accommodation and residential services, early childhood education and care services, education services, including schools, health services and community services will then be phased in. And stage 3 or phase 3 will commence on the 1st of April 2026. So religious bodies, commercial services for children, transport or transport-related services for children, and services or activities provided primarily for children will come into the framework from the 1st of April 2026. So that means in the next 12 months, all of those types of sectors will be covered by the scheme. So please be aware when your organisation comes under the scheme and make sure you are complying. So as mentioned before, the Reportable Conduct Scheme is a scheme that oversees allegations of child abuse and misconduct within institutions. The Queensland Family and Child Commission is the regulator that has been set up to oversee the Reportable Conduct Scheme in Queensland. The Reportable Conduct Scheme applies to organisations with a high degree of responsibility for children or organisations which engage in activities where there is a high or an increased risk to children. Organisations who are required to comply with the scheme are referred to as a reporting entity under the Act. The Reportable Conduct Scheme requires reporting entities to report any reportable allegations or reportable convictions to the QFCC within the prescribed time period and investigate any concerns about the conduct of its staff or volunteers in relation to their work with children. Not all organisations who are required to comply with the child safe standards will be required to comply with the Reportable Conduct Scheme. However, any child organisation that is required to comply with the Reportable Conduct Scheme is required to implement the child safe standards. So in other words, all reportable entities must comply with the child safe standards as well. In addition to obligations to report certain types of allegations to the QFCC, the head of the organisation is also required to comply with the Reportable Conduct Scheme and must ensure that there's systems in place for preventing reportable conduct, reporting, investigating and responding to reportable allegations against their workers or reportable convictions against their workers. They must notify the QFCC of reportable allegations or convictions, as I said. They must arrange for an investigation of the reportable allegation or conviction and provide a final report to the QFCC and provide any other information as requested by the QFCC. In Queensland, reportable conduct is defined in Section 26 of the Child Safe Organisation Act to include 6 different types of reportable conduct. Now, it doesn't mean that a person has to be convicted or charged with an offence in order for it to be reportable conduct. In that, if these types of allegations are made, whether or not police investigate, whether or not it ends up in a conviction or not, it may still be reportable conduct under the scheme. So the 6 types of categories are, firstly, a child sexual offence, which is a child sexual offence under the Criminal Code or Section 207A of the Criminal Code, an offence of a sexual nature committed in the presence of a child, an act or omission committed outside of Queensland that would be an offence mentioned in paragraph A or B if it were committed in Queensland. So whether it's an offence within or outside of Queensland, it will still fall under the definition of a child sexual offence. Sexual misconduct committed in relation to or in the presence of a child means conduct that is sexual in nature, other than conduct that constitutes a child sexual offence. So examples of a conduct that might be sexual misconduct might include inappropriate touching, voyeurism, use of sexual language without a legitimate reason. There's a number of types of conduct that may constitute sexual misconduct. What we often see in reportable conduct investigations is allegations of grooming falling under this particular category of misconduct. Ill treatment of a child means conduct towards the child that is unreasonable and seriously inappropriate, improper, inhumane, or cruel. So some examples of that might be making excessive or degrading demands of a child, a pattern of hostile or degrading comments or behaviour, using inappropriate forms of behaviour management. That might all fall under ill treatment of a child. Significant neglect of a child. Neglect means a failure to meet the basic needs of the child and that it was deliberate or reckless. Physical violence committed in relation to or in the presence of a child means the intentional or reckless application of physical force to a person without lawful justification or excuse, or an act that intentionally or recklessly causes a person to anticipate immediate and unlawful violence to the person, but it does not include the application of trivial, negligible, or insignificant physical force to the person. In Queensland, the Reportable Conduct Scheme requires organisations to notify the Queensland Family and Child Commission when there are allegations or convictions of reportable conduct committed by an employee or volunteer. And I should note, my apologies, it also includes that the final type of reportable conduct was emotional or psychological harm, behaviour that causes significant emotional and psychological harm to a child. And emotional or psychological harm to a child means detriment to the emotional or psychological well-being or development of a child. What we'll often see in reportable conduct investigations is not just one category. So it may be that there's an allegation of physical violence, for example, but there also might be an allegation that in the same incident has caused significant emotional and psychological harm to a child. So it may be that there's just one specific incident and one type of reportable conduct type, but it may be that there's multiple different types of reportable conduct types that are reported in one incident. It can also be that initially an allegation is made and we are investigating one particular allegation, but once we start investigating, we might find that other children have been affected, or it might be that there's multiple types of reportable conduct that end up being reported, which means the scope of the investigation might increase. So please be aware of that as well. So the head of a child safe organisation, or a reporting entity, I should say, will be required to ensure that systems are in place for preventing, reporting, investigating and responding to allegations and convictions of reportable conduct, notifying the QFCC, arranging for allegations to be investigated and provide a final report to the QFCC, and as I've said previously, provide information as requested to the QFCC. So Section 27 of the Act sets out what the meaning of a reportable allegation is. So a reportable allegation is an allegation or other information that leads a person to form a reasonable belief that a worker of a reporting entity has committed reportable conduct or misconduct that may involve reportable conduct. And in order for it to be a reportable allegation, it's irrelevant whether or not the conduct or misconduct is alleged to have occurred in the course of the worker performing their work or outside of their role. So that's a really important thing to remember in the reportable conduct scheme, that we're not just looking at the person within their role. It could be that something in their private life has happened and an allegation has been made on that basis, and therefore it still must be reported and investigated. Similarly to the Child Safe Standards implementation, there will be a phased approach in relation to the reportable conduct scheme as well. So the implementation of the reportable conduct scheme will commence from the 1st of July 2026. And there are 3 phases which outline which organisations are required to implement the stages and when. So phase 1, which commences on the 1st of July 2026, will include child protection services, services for children with disability, justice or detention services and government entities. So they will all fall under the reportable conduct scheme from the 1st of July. From the 1st of January 2027, accommodation or residential services, education services and health services will fall under the scheme. And from the 1st of July 2027, religious bodies and early childhood services are among those that will fall under the phased implementation. I know in Victoria there was a phased implementation of the reportable conduct scheme, and then once that phased implementation occurred, there was more organisations that were joined to the scheme as well. And even the definition of worker within Victoria has been widened since the scheme initially came into effect. So it may be that legislation is continually amended, so please This is the basis of the current legislation, but it may be amended over time. So please be aware that even if you aren't one of these reporting entities yet, it may be that eventually you are. So what I'd like to turn to now is what should organisations be doing now? We know, as I said before, many clients find that it's quite onerous when these new schemes are developed. There is a phased approach. And what we commonly see is regulators really taking a supportive and informative approach to helping clients or helping organisations comply with the child safe standards in the scheme. And over time, after there's been quite a period of time where organisations should have already complied with the scheme, that's when we see a little bit more of the regulator starting to question why organisations aren't complying. So at this stage, it's really, really important you start looking at, well, am I complying now? Or what do I need to do to ensure that I'm complying? And going that even step further, well, what's best practice? So it's vital, first of all, that organisations understand their obligations under the Child Safe Organisations Act. Is your organisation a child safe entity and therefore required to comply with the child safe standards? Is your organisation a reporting entity and therefore required to comply with the Reportable Conduct Scheme? So that's probably the first question you have to ask yourselves. Does my organisation fall within this new framework? And depending on what sort of entity your organisation is, will depend on what steps you need to take now. So if your organisation is a child safe entity, then you must start reviewing your policies and procedures. Do you have a child safety and wellbeing policy, a reporting procedure, a child safety code of conduct? Does your organisation have a public commitment to child safety, which is embedded in all your policies and procedures? Do your policies and procedures comply with the child safe standards? So you may want to start considering having your current documentation audited or reviewed against the child safe standards to see where your gaps are. And once you know where your gaps are, then you can address those gaps. It takes work. It's not something you can just tick the box and say it's done, because even if you do make amendments to your policies and procedures, there's no point in having policies and procedures unless they're implemented. So then you need to look at that implementation stage and what you then need to do to ensure that all your staff are aware of the child safe standards and making sure that they are all complying with your policies and procedures. So once you sort of know where your gaps are, then you can amend or draft your policies and procedures. And there's some really good resources online across different states. Regulators, they have different resources. However, it can be time consuming to get right. So you may want to seek assistance from an external safeguarding provider, such as Safe Space Legal, in order to really get those policies and procedures right. What we often find is doing investigations, we can often see where risks are because we've obviously done a number of investigations and we know where those gaps are. So really trying to use someone who has that expertise and understanding where the risks lie so that you can try and mitigate that risk before things go wrong is a really good step to take. You should ensure you have child-focused and trauma-informed complaints handling processes in place. Now, if you're required to comply with the Reportable Conduct Scheme, it's absolutely vital. You have to have, as I said, the head of entity must have complaints processes in place which are child-focused that respond to reportable allegations. But Child Safe Standard 6 also requires that you have child-focused complaints handling processes in place as well. So even if you aren't required to comply with the Reportable Conduct Scheme, your entity may still be required to comply with the Child Safe Standards, which means you still need to have child-focused complaints handling processes in place. It's absolutely vital that you know what process your organisation will take if a reportable conduct or a child safety incident occurs. I say this because regardless of who you are in the organisation, being involved in a reportable conduct or a child safety matter is very challenging, and it can cause immense stress for all those involved, for the child, for the family, for staff members who may have witnessed it, for the respondent, for the head of entity, for the people who are managing staff expectations and families' expectations. It can be incredibly challenging. So have your procedures and your processes in place now. Have your policy ready to go. Have your templates ready to go. What are you going to say to people if an allegation is made? What letters are you going to draft and send out to people, if an allegation is made? It's really, really important that you have that at the forefront of your mind and all your staff are aware of what needs to happen if an allegation is made so that there's no delays and that things are responded to appropriately. It's also really important to consider consultation at this stage. That's probably one of the biggest shifts that we've found when child safe organisation frameworks come in within a state. It's not just about the organisation drafting policies and procedures and publishing those and saying now everyone must comply. There has to be a level of consultation. What that looks like for each organisation will differ, but it's really, really important to consider consulting with children, families, the community, including Aboriginal and Torres Strait Islander communities, to ensure that your policies and procedures properly reflect a culture of child safety, and really empower children and young people to be involved in decisions that affect them. And that leads us to the end of the webinar today. I just wanted to recap that Safe Space Legal has offices in both Melbourne and Brisbane, and we provide services to organisations across Australia exclusively in child safety and safeguarding. We provide a number of different services, and we're a very holistic practice. We have, as I said before, a number of people within our organisation who have a very holistic approach in that they've worked in child protection for many, many years, social work. We've worked both within organisations, so we understand the challenges that sometimes organisations can face when you are in-house. And we've also supported many, many organisations across Australia to ensure that children and young people and vulnerable people are safe within the organisation. So some of the services that we provide at Safe Space Legal include investigations, including under the Reportable Conduct Scheme. We conduct child safety training, which can be tailored to the organisation and really try and fill some of those gaps in knowledge and upskill your staff. We conduct child safety audits, gap analysis and reviews against the child safe standards. So we will review your policies and procedures and the implementation of those policies and procedures against the child safe standards. We provide legal advice, which is subject to legal professional privilege. We develop policies, procedures and templates for organisations. We do audits of critical incidents and risk mitigation, and we represent clients in enforcement action if and when needed. But as I said before, what may set us apart is the fact that we are a law firm. So much of our legal advice is protected by legal professional privilege, which may assist your organisation to make informed decisions to move forward and make sure you're complying with the scheme that is being implemented. We also have the Safe Space Support Line, which is an on-call 24/7 support line where we give high-level legal advice for child safety incidents, reportable conduct matters and the like. And coming in 2025, we are incredibly excited to announce that we will be launching Safe Space Training, which will be an online child safe modules to provide child safety training to organisations across Australia, including Queensland, in relation to the new framework. Thank you very much for your time. It has been a real pleasure presenting to you today. If anyone has any questions or they wish to ask following the webinar today, please write your question in the chat or send us an email and we'll get back to you as soon as possible. We also offer a half-hour complimentary MS Teams meetings to discuss your organisation's safeguarding needs and how we might be able to assist you moving forward. And we especially love doing this with organisations when new legislation comes through, so we can really help and support and guide organisations, because sometimes it can feel really overwhelming, and that's what we're here for. Please don't hesitate to contact us, and thank you for your time today.